Hello everyone. Welcome to Jurisprudence 2 lectures. I am Marjina Sultana from Indraprastha Law College, Greater Noida. In this video, we are going to discuss remedial liability. Remedial liability. Remedial liability is based on the Latin maxim ubi iusi vire medium. We must remember here that it is pronounced as ubi iusi vire medium, not as ubi jus ibi remedium. It means for every wrong, the law provides a remedy. Wrong means breach of duty. So ubi iusi remedium means that for every breach of duty, there is some remedy prescribed by law and it is enforced by law. Remedial liability is also known as specific performance. Its sole purpose is the enforcement of plaintiff's rights. It is useless to imagine and think a right without a remedy. So whenever law confers rights and imposes duty, it also enforces its specific performance. The purpose of remedial liability is to remedy the injury caused by any violation of rights by compelling the person bound to comply with it. Where one's right is denied, law affords the remedy of an action for its enforcement. It is necessary to keep in mind that both the rights violated and the remedy sought to be obtained should be legal. Because there are many moral and political wrongs, but they are not actionable in court of law, as they are not recognized by law. Examples of remedial liability. Liability to deliver the goods identified to the contract of sale. If the goods are identified to the contract of sale and the goods are in the possession of the seller, a court may order that the goods be specifically delivered over to the buyer upon payment of the price. Another example is liability to pay the loan or debt. Suppose a person A takes a loan from another B and B deny to pay off the loan. The court can specifically enforce A to repay the loans to B. Exceptions to remedial liability. There are three exceptions to remedial liability. First one is imperfect obligation or duty. The breach of an imperfect duty gives no cause of action, that is to say, creates no liability at all. In this type, law recognizes right to perform, but it cannot enforce it. For example, a time-barred debt. A debt barred by the status of limitation is a legal debt, but it cannot be enforced by law as the right to sue is destroyed. There can be no legal proceedings to compel its payment. Second example is unenforceable duties. There are duties which from its nature cannot be enforced after having once been broken. For example, in a completed assault, the defendant cannot be made to refrain from it as it is already done and the original state of the things cannot be brought. Another example is libel. Once the defamatory statement has been published and the reputation is harmed, we cannot undo the harm. It becomes impossible in the nature of things to enforce specifically the duty of refraining for the simple reason that it is too late. Wrongs of this nature cannot be remedied. They can only be awarded damages or punished. The third exception is inexpedient duties. In cases where the specific performance of the duty is inexpedient or inadvisable, the law, though capable of enforcing, refuses to enforce the specific performance of the duty on other considerations, but instead provides pecuniary compensation to the plaintiff. For example, promise of marriage cannot be specifically enforced for the obvious reason that it would be inexpedient and inappropriate to enforce it. Even if the court enforced the marriage, There may arise the differences between the parties, ultimately ending their relation in divorce. Another example is contract of service. If a, if a person A contracts to render personal service to another B, B cannot enforce performance of this contract as per Section 21 of the Specific Relief Act of 1877. Thank you for watching this video.